Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. A recent case has highlighted the danger of failing to serve notices according to the precise terms of the contract. In this case, Zao Group purchased a business from Ainger and 6 other people. The business sale agreement stated that any claims must be served on all of the sellers at their specified addresses and within a prescribed period. On the last day of that period, the claim was served, but as one of the sellers no longer resided at the specified address, the courier served the notice to an alternate address. This was fatal to Zao's claim as it breached the clear terms of the notice provision. In addition, the court stated that the claim document was also fatally flawed. The claim had been valued incorrectly and therefore breached an express term of the agreement to provide a reasonable estimate of the value of the claim. The Zao case and other recent cases we have reported on demonstrate that where the terms of the contract are clear, the courts will generally not be willing to interpret them, even where the literal words have bizarre consequences that no party could have intended. Another recent case, Sparks v Biden, has clarified that the courts will imply a term into a contract where it is obvious and it goes without saying. In this case, Sparks sold a plot of land for the development of residential houses. The sale agreement obliged the developer to proceed as soon as reasonably practicable to develop the land in accordance with the planning permission. This was important to Sparks as he was entitled to an overage payment upon the sale of the houses. The developer then decided to rent out some of the houses rather than selling them, stating that the overage payment would only apply when the houses were sold and that it had complete discretion as to when the sales would happen. The court agreed with Sparks that the agreement had obviously meant to oblige the developer to sell the houses within a reasonable time. Without this term being implied into the agreement, it lacked any practical or commercial coherence. The recent data protection updates include the ICO has announced that although GDPR removes the obligation on data controllers to submit annual notifications about their data processing, data controllers must still pay an annual fee. Current fees are £35 or £500 depending on the size of the business. The new fees are expected to be announced soon and we anticipate that the highest fee will rise to £1,000. The European Commission has published new GDPR guidance on data protection impact assessments, personal data breach notification and on automated individual decision making and profiling. The guidance documents are available on the European Commission's Article 29 Working Party website. There has been some intense lobbying concerning the EU e-privacy regulation. This regulation is expected to also be enforced at the same time as GDPR in May next year. Within this regulation, there is a provision that requires consent for phone marketing. However, the UK is entitled to opt out of this obligation. In September last year, we reported on the Employment Appeal Tribunal's case of Royal Mail v Jutty. The EAT, overturning a lower tribunal decision, decided that an employee had been automatically unfairly dismissed as she had made a protected whistleblowing report to her line manager, even though the dismissing manager was not aware of it. The Court of Appeal has, however, now overturned this decision, taking the opposite view to the EAT. If a dismissing manager was not aware of the protected whistleblowing report, then the employer could not be liable for that mistake. A recent European Court decision has clarified that a breastfeeding mother is entitled to a specific assessment into her individual situation and for appropriate adjustments to be made to working practices. The employer cannot dismiss her concerns simply because it has already undertaken a standard risk assessment. In the case of NHS 24 v Pillar, the EAT decided that an employer investigating an incident can consider earlier incidents even where they did not result in disciplinary action. In this case, Pillar, a triage nurse, was investigated in 2013 and subsequently dismissed after she failed to ask appropriate questions that resulted in a heart attack patient being referred incorrectly. Now, Pillar had been subject to 2 prior investigations that had resulted in additional development rather than disciplinary action. and an earlier tribunal decision had held that the dismissal was procedurally unfair because it was unreasonable for the employer to consider past incidents when making its decision. The EAT disagreed. To follow the tribunal decision would have penalised the employer for conducting a thorough investigation. The case of Baker v British Gas Services has again highlighted the risk that employers face when employees are transferred to them under a TUPE transfer. In this case, Mr Baker had suffered an electric shock in 2012 when he worked on a light fitting that had been incorrectly installed. The shock caused him to fall off his ladder, hit his head and suffer brain damage. Mr Baker's employer had been responsible for the maintenance of the light fitting, and the investigation of the case found that Mr Baker's colleagues had been negligent by not identifying the incorrect installation during routine inspections in 2009 and 2010. After the inspections in 2010, Mr Baker and his colleagues were TUPE transferred to a new employer. Mr Baker sued his current employer for the negligence of his colleagues, even though the negligence had happened when his colleagues had worked for the prior employer. The High Court agreed with Mr Baker. He could sue his current employer. The effect of TUPE law was to make the current employer responsible for the current and past acts of the employees. The recent Competition Appeal Tribunal, the CAT, case concerning Balmoral Tanks, BT, appeal against a fine imposed by the CMA highlights the importance of competition law compliance programs. BT could not deny its representative had attended a meeting where confidential pricing information had been exchanged, as the meeting had been covertly filmed. They did argue that it had not infringed competition law. The CAT acknowledged that BT's representative had initially stated that he did not want to be part of the cartel, but this did not help BT as its representative stayed at the meeting and disclosed and commented on pricing information. The fact that the representative only attended one meeting, had no authority to set prices, disclosed information that may have been deliberately incorrect, and that the meeting did not have any anti-competitive effect, did not allow BT to escape liability. BT's final argument was that the pricing information that had been disclosed was in any event public knowledge, as the customers would show each supplier its competitor quotes. This argument also failed. The CAT held that the meeting showed a deliberate attempt to coordinate prices, and that, by itself, was sufficient to justify a prosecution. Recent reports indicate that only 50% of companies that are required to publish slavery and human trafficking statements have done so. That's companies that have a turnover of more than 36 million. And many of those statements that have been published are deficient. The government has now issued new guidance on the gov.uk website. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis.